Still with me, trial attorney Rachel Fiset. Rachel, what do you make of the judge's decision in this case? And I ask that because I've seen recently in cases, especially the George Floyd death case, where the judge did rule that the prosecution could not use victim. They wanted to use words, Mr. Floyd, instead of defendant, Mr. Chauvin. Here, the judge is adamant that even though this is a self-defense case, these prosecutors can say that Clearman was a victim.
Well, and the judge in the Rittenhouse case wouldn't allow the prosecution to use the word victim either. And that, to me, was a pretty terrible ruling, because if someone is murdered, there is a victim. So here, I think the judge has made the right call. I think it's unusual not to allow the prosecution to use the word victim, particularly in a murder or homicide case in any kind of way. So I think the judge is setting a more equal playing field in this court, and that's what's going to come out. He's saying, I'm not trying to tell anybody basically how to run their case, and I'm allowing this to come in.
There was video in this case, video of two parts of the encounter between the defendant and the victim. The initial encounter, though, the one that the defendant claims was when he was run off of the road by Clearman, that's a video that doesn't seem like it's going to be coming into evidence, or may not even be in evidence. But then the initial punch from the defendant to the victim, that is something that was shown and has been shared. And then, of course, the actual shooting. Here's a listen to Liz Brown. She's with Justice Wisconsin. She was at a press conference this week on behalf of the defendant. Here's what she had to say about that evidence.
How did they receive the 7:45 footage that shows Mr. Edgecomb punching Mr. Clearman through a window, but there's no 7:30 footage of him being knocked off his bike, him being called the N-word? Where's the rest of the footage? Did it disappear?
Rachel, so she's saying that video is missing. Do you think a jury is going to care that that initial video isn't going to come in, but they have these other two moments?
Well, that initial video would show perhaps why the defendant was so angry, and it may even show why he believed that he would be in danger of great bodily harm or even worse. So I think that video may be important, but on the flip side of that is that video shows a time period before this incident happened and at a time when the victim could get away. So in self-defense law, you're supposed to cut off the time where you could get away and the incident has stopped and you're no longer in grave bodily danger. And so the ruling that this has stopped it, and then it was re-picked up later, it does go both ways. I see this as a close call, because if you can get away, you don't want to develop a line of self-defense cases that allows you basically to go defend yourself when you're no longer in harm's way.
This is going to be a difficult case to parse through the information. We, of course, are going to continue our coverage of the deadly road rage shooting trial. It begins on Tuesday, January 18th, 9 a.m. Eastern, right here on Court TV Live.